Можемо почати.
Good morning, everyone. Доброго ранку всім присутнім. Буквально хвилину технічних питань, поки всі під'єднуються. У нас трансляція буде в перекладі українською, тому прошу всіх, хто приєднується в себе внизу в Zoom, включити український канал, тому що спікери у нас будуть виступати англійською мовою, і у нас буде здійснюватися паралельний переклад. Good morning, everyone. We have begun our webinar about digital economy, virtual assets enforcement and recovery, and our panel discussion with international experts, law enforcement officers and agents from different parts of the world. And we are trying to share best practice and best experience in working with difficult cases with cryptocurrencies. So for welcome speech, I want to invite and pass word to Oksana Rusecka. She is head of Association of Private Enforcement Officers of Ukraine. So, Oksana, welcome to your welcome speech.
Так, добрий день, шановні колеги. Я так розумію, що нашим іноземним гостям здійснять переклад, так? Тому що, на жаль, на сьогодні моя англійська, вірніше, не така досконала, щоб на ній виступати. Я, перш за все, дуже рада бути тут сьогодні і дуже дякую шановним організаторам за те, що ви піднімаєте такі важливі теми на обговорення, на висвітлення, особливо Олександру Черник, так, за те, що ви залучаєте наших іноземних колег, які готові поділитися дійсно практичними кейсами та досвідом звернення стягнення на віртуальні активи в своїй країні. Тому що в Україні, на жаль, на сьогоднішній день немає, наскільки мені відомо, практичних кейсів звернення стягнення саме на віртуальні активи боржників. Є випадки накладення арешту на віртуальні активи, але ж вони все ж більше у кримінальних провадженнях, так, в тому випадку, коли у слідчих напряму є доступ там до мобільних застосунків та до кодів доступу до відповідних віртуальних гаманців, але у виконавчому провадженні, на жаль, на сьогоднішній день не дуже складається, скажімо так, система звернення стягнення на віртуальні активи. Тому ми будемо вчитися у наших іноземних колег і переймати досвід. На сьогодні в Україні вже є прийнятий закон про віртуальні активи, однак він не набрав чинності, тому що був і заветований президентом, і пізніше набере своєї чинності після внесення змін відповідних до Податкового кодексу України. Є також відповідні законопроекти, які зроблені для набрання чинності законом України про віртуальні активи. Однак, на жаль, рядом тих законопроєктів встановлено, що не встановлено процесу звернення стягнення на віртуальні активи боржників. Тож Україна на сьогоднішній день, хоч і посіла 5-те місце серед 154 країн світу в рейтингу за глобальним індексом впровадження криптовалют. Однак, на жаль, ми не маємо відповідного законодавчого регулювання та практичного застосування звернення стягнення на віртуальні активи боржників. Тож я також з цікавістю сьогодні дивлюся у цей день, у наш сьогоднішній захід, і будемо переймати досвід у наших іноземних колег. Дякую.
Thank you very much. And I pass for first speech and first discussion to Evgeny. Evgeny, head of department of cyber police of Ukraine. Evgeny, welcome.
Thank you. Thank you very much. Just one remark. I'm not the head of the cyber police department. I'm just the head of division from this department.
Sorry, division of department. Yeah.
Yeah. In this division, we also investigate the cases that related to the cryptocurrency and virtual assets. So that's why probably I'm the speaker on this conference and will represent to us all our experience that we have during the full-scale war and till it's happened. So the few words about me. Had really huge experience in analyze the crypto assets and blockchains. I'll also investigate many cases that related to the traditional financial system and then also to the cryptocurrency and virtual assets. We have in our department also the largest numbers of requests from our citizens about the cases that also where we can also find the virtual assets. And just to clarify what the cases we investigate in our department, as you can see, it's 5 different areas, and probably the most important and the biggest numbers of requests from our citizens we received about the online fraud, then about the hacker attack. It's also crimes related to the and committed in the field of illegal content, economic crimes, and general crime investigation, because we now also support all the units from the national police. If we have some like IT technology that was involved in the crime committing scene or virtual assets, all units from the national police could request us some support, and all our units try to help in the cases where our colleagues need our help. As you can see, in online fraud, we have really popular ways to scam people in the investment scam, in pseudo exchange services or projects. If we talk about the hacker attacks, really often we can see unauthorized interference with the system or devices, especially in Telegram. It's now really popular in Ukraine when someone hacks your Telegram account and then send the messages to your friends and just ask to some money or other assets. It could be also virtual assets. If we talk about the traditional financial system, our criminals often use the virtual assets to then money launder and of course hide the trace or adopt their crimes to the way that's not easy then for the investigator or analysis to trace the transactions and find the correct answers for the prosecutor or in the court. Also, we can talk about the next criminal case. It's a payment for goods or services that are prohibited in circulation. It's drugs, weapons, child pornography, malicious software. It's really popular now, where you can find that products or services and pay use virtual assets as a payment method. Of course, it's ransomware. You can ask to develop some ransomware and pay for that in virtual assets or in crypto, or sometimes we can see as a result of work the ransomware software that in the results of decryption all data or encryption all data ask to pay for decryption by the virtual assets. Sometimes we can see also contracts for killers and other hooligans against certain individuals, where also cryptocurrency is used as a payment method. From the first day of the full-scale war, we also start to investigate the cases related to the Russian criminals who occupied our territory. We try to identify also Ukrainian citizens who support the occupation forces. We start to find all the virtual assets wallet and the clusters that Russians use for their fundraisers campaign to collect and save money and support their illegal troops or soldiers. Today, we see that Russians also use virtual assets as a means of raising funds and also as to circumvent sanctions. During the investigation of crimes, we come across direct state transfer from the Russian budget made by Russian officials. Transfer of funds from wallets contributed and controlled by FSB. All these trends are in part of our investigations, and all this information standard to our intelligence. Now in Ukraine, we see that IT industry and the cryptocurrency market continue to develop rapidly, and people in Ukraine see cryptocurrency as an innovative tool for payment and saving. We, as we just discussed in the start of our conversation today, we haven't any current and basic law that regulates virtual assets, but some parts of the virtual assets means and also regulation included in the other legislative and law. Of course, we can work in our criminal case, we can investigate cases related to virtual assets, but unfortunately, we still have not any practice to seizure assets, especially to the budget of Ukraine. Today, support of the whole world for Ukraine is really important and it's vital for Ukraine. So I just will mention that any kind of information that you probably collect or received from any partners, and if you can find the Ukrainian citizens or any related information for the Ukrainian law enforcement, we really like to have that information and cooperate with you, exchange this data and try to find some results in the case that you have. For that way, we just wanted to show one resource that we create for our citizens. You can left your order just on the site. I used ticket.cyber.gov.ua, and you can left all your order about the crime that was committed against you, or also recommend this resource for other victims if you know about them. From my side, it's probably all the things that I will mention. We always open for the cooperation. You can find probably my contacts after the conference, and maybe organizers will send my contacts and this presentation for you. Really open again for any kind of relation and cooperation. So thank you for the time, and thank you for this opportunity to speak to all the audience.
Thank you, Evgeny. It's very interesting and very important to us to know how it's open work, our cyber policy in Ukraine, and if actually we can order about crypto crime online and don't use any paperwork. It's very important, some facilitation of our lawyers' job. Thank you very much. And next speaker will be Massimiliano. Massimiliano, I just share your presentation.
Thank you.
And sorry, 1 minute. Massimiliano, you can start. Massimiliano Blasone, welcome.
Thank you. Good morning, everyone, and thank to the Ukrainian Bar Association for the kind invitation. I'm an Italian attorney at law, and I'm a kind of enforcement agent because I'm a professional delegated to the sale of foreclosed assets. I'm appointed from the court, and so I carry out the online auctions and all activities like foreclosure, but only in real estate. But in any case, I'm not here to share with you Italian best practices in this field, but only to introduce our law and its limits, because I think that European enforcement systems are very similar and they have very similar issues. And for the reason, professional sharing their experiences or sharing point of discussions or proposal are able to find, in my opinion, solutions that can be used to be applied in each European country. So we start with my presentation. Thank Alexander for the head, because I'm not in office, so I'm abroad and I'm not have my usual connection. We can start with the next slide, please. And I would like to tell firstly that cryptocurrency, according to Italian law, is legal money, but isn't legal tender. Doesn't have to be registered, because we have since 2025 only a register of a service provider of wallet and exchange, but not of the owner of crypto asset. I mean, cryptocurrencies and FT, for example. Cryptocurrency is a mobile asset according to our legislation, and is an intangible asset because it consists of computer codes, as you know, and has an economic value, being measurable by a fiat currency. So for the reason it can be foreclosed, and we don't have a specific rule governing this foreclosure, so must be applied the general rules or civil procedural code for the foreclosure of mobile assets. And in the next slide, I would like only to point out some preliminary consideration, because in order to be foreclosed, like any other assets, cryptocurrencies must be found. And as you know, all cryptocurrency are stored in a digital wallet. Each wallet has two types of codes, public and a private one. The public key, public code, is shared with the other user of the blockchain or the system, and contains the address and identifies the owner and is used to receive the payments. The private key is secret, known only to the owner of the wallet, and use it to sign and to authorize the transaction. Wallet can be divided in three categories. The first two are hardware and software wallet, managed independently by the owner, who has the possession of them, has the password, and signs digitally the transactions. And the hot storage web wallet is managed through a company's online platform, exchange company. So it's important because the first two has, according by our law, a same kind of foreclosure, and there are same issues. You can change the slide, because in case of foreclosure of hardware and software wallet, in Italy we can find summarize some general issues. The research of the wallet by judicial officer at first, because the first issue is really related to the place where cryptocurrencies are stored. Because going a bit deeper in the topic, they don't contain them, but only the codes to use to be able to order the transactions. So the possession of the wallet by the judicial officer doesn't prevent the debtor's avoidance actions. And debtors is often is able to use a so-called mnemonic, seed phrase, a backup phrase, is a list of words, and with them is able to back up in another device the wallet, for example, foreclosed from the judicial officer, and enter in another, but the same wallet, and use and spend the money. So another one is belonging to the debtor, because the question is, how does the judicial officer know if a debtor is the owner of the wallet or not? By us, there are four possibilities. The first is that during the search, the judicial officers finds in a place belonging to the debtor an hardware or a software wallet. And in this case, there is a presumption of law belonging to the debtor, but must be found the wallet. Secondly, by communication of the creditor, for example, because creditor and debtor have a contract with the payment in cryptos, or to the access by judicial officer at the tax registry, an electronic access. But here the issue is you have to know if debtor has declared or not to the tax authorities the cryptos for income tax purposes. And the less theoretically possible way is by consulting the register of exchange and wallet providers. As I told you, introduced by law in 2022, the register is a list of the providers authorized to work in Italy, and they must communicate also the names of the clients and the transaction performed to the public authority. But there are a lot of but. It isn't a register of the owner, so not all owners are registered. Judicial officer currently doesn't have access to it, and in any case, password or private keys in particular are not communicated. So it's a very useful instrument for anti-money laundering purposes and to fight tax evasion, but not currently is usable for fine foreclosures the cryptos. In the other case of a web wallet called Alex changed the email, we have not similar but quite similar issues, because in this case, as I told you before, as you know, there is a exchange company, and so to find the company, the first issue is the access to the register, and there is not possible for a judicial officer currently. And the exchange company are usually based abroad, and in this case, you have to start with a cross-border enforcement, and all cross-border enforcement need time, and time isn't a good friend of the foreclosure of cryptos, because they change value very soon, and also the debtor is able to spend them incredibly soon. So another identification of the debtor, because the exchange companies in a lot of cases guarantee anonymity to the owner. So if you want to deposit the cryptos online, you must have only an email account and a password. And also the hot storage is a little used. So although in this case is difficult to find the asset before foreclosure it. We have quite, in the next slide, I will tell about a quite new rule on the Civil Procedure Code, because in 2009, our legislator introduced a statement of the debtor to the judicial officer. Alex, if you can change the slide, you can see. In this case, in Italy, only in case of lack of mobile asset and in attendance, only in attendance of the debtor, judicial officer invites the debtor to declare if she has other asset, also cryptocurrencies, and where they are located. And he informs that the omission or false statement is a crime. I found similar rule in the Civil Procedural Code of Germany and Finland. In this case, the lack of collaboration, or the lack of true communication is not a crime, but only a financial sanction. It's a fine. In Thailand, we have incredibly almost same rule with the same words, and it's still a crime. But it's a crime. But the limit of the rule is that the judicial officer isn't able to check if debtor told her the truth or not. For the reason, it's probable fruitlessness, the foreclosure in Italy, because it's very difficult currently to find the wallet. It's almost impossible without the collaboration of the debtor to know the private key to operate, to use or to transfer them from the wallet of the debtor to the wallet, a judicial wallet of a judicial officer. And for the reason, we in Italy must check around, check abroad, and to find some solution. I would like in the second part of my presentation to introduce some recommendation coming from the soft law. In the next slide, I will introduce in very few words the digital global code of enforcement published by the UIJ, as you know, is an international union of judicial officers and enforcement agents. If I remember, in 2019, if you can change the slide, we will see some indication about it. You can find it online on the website of the UIJ, and it's a great work carried out under the aegis of representatives from all continents, attorneys of law, judges, judicial officer, professor, and a lot with a lot of people that worked for this result, with a purpose to define universal principle which a country should introduce to govern the use of digital technologies in enforcement. And this reflects really the point of convergence of all enforcement systems around the world. And in this code, there are also some proposals, some for standard procedures for foreclosure, for seizing crypto assets. I summarized them really in a few sentences in the next slide, because firstly, the global code proposed to introduce a national crypto asset register with an obligation of declaration by person involved, debtor and exchange companies, with the access of enforcement agents to this register, and also an obligation on the debtor and the parties to declare since the beginning of the foreclosure crypto asset and their keys to the enforcement agents, and suggest proposals to introduce by law also sanction for non-declarations or financial sanctions, fine, or alternative measure as a temporary withdrawal of documents, or also to introduce a crime of deprivation of liberty. There are very important steps, very important recommendation. And then, so in my opinion, would like to be only a proposal of discussion, a stimulation for the discussion, because in the next slide, I propose another approach that could be useful, because as I told you, the collaboration of the data is essential. At the suite of sanction, maybe it could be not work very good. So, in my opinion, it could be useful also to introduce a cooperation with the debtor, with a reduction provided by law of the debt in case of positive declaration of the debtor. There is something similar in the Civil Procedure Code of Belgium, in particular in the side related to the auctions of foreclosed asset, because the enforcement judge is able to reduce the debt in case of collaboration of the debtor with a judicial officer until 5% of the debt can be reduced. And it could be a good stimulation, in my opinion, as the promotion of the mediation by attorney at law of the parties. I propose also to provide, by law, could be useful, a mandatory transfer of the foreclosed cryptos to the professional wallet of the enforcement agent, because, as I told before, with mnemonic, it's very easy currently to use the foreclosed crypto asset by the debtors, lawyers, and to provide also an immediate assignment in payment of cryptos to creditors in case of his her request, because it's a legal tender, or an immediate forced judicial say through an exchange company by judicial officer, by enforcement agent. In any case, in my opinion, is to avoid a judicial auction due to the fast changing of value during the time required for the advertising, for the publication of sale notices, and the organizing of the tender. So this is my few words about this topic, and I will listen with great interest your other speeches. and your opinions. Thank you for your attention.
Thank you, Massimiliano. Thank you very much. Good your opinion. And I have one question. All enforcement procedure, what we just had listened from you, we talk about white virtual assets providers and violet or white exchanges. If we talk about transfer money and some using some cover company from debtors in gray markets, do you have some experience? Of course, if our debitor not declarate own assets, it's criminal according to Italy law. But from my opinion, many debtors try to circumvent assets and use different companies, different gray jurisdiction and unregulated crypto markets for assets. Maybe you have some answer for this, or maybe some experience or recommendation for our colleagues.
Well, I never foreclosed cryptos because the judicial officer never found them, even though creditors know about them. And yes, you told correctly, but it's difficult that someone that wants to have a criminal behavior collaborate in case of a threat of another sanctions. Must to take it out from the hidden side and to promise something to collaborate, because for sure the recommendation of the UIJ are fundamental with a register, national register, in the case of mandatory registering of the owner, all the owner of cryptos, you can know where who had them. But the second step could be very difficult, because if someone is a criminal, don't like to tell, doesn't like to tell where have the hidden money. So I don't know if some theoretically provided by law could work very well without a stimulation, a promotion, or an agreement. I'm talking in the enforcement field. Another field is anti-money laundering or fighting tax evasion, because there are also different types of behaviors. To foreclosure an asset, you can find it, you must find it, and you must have the possession and provide the data of it, because you don't have other choice for give it or the revenue from the sale of it to the creditor. So.
And one question also, according European and Italy law as well, do you obligate to have own virtual wallet special for these cases, special enforcement procedure? Did you need to open additional wallet for all cases, or maybe one, as our enforcement officers has our own bank accounts for special procedure, enforcement procedure? Maybe you have some requirements as well for crypto cases as well.
I think that one official of the judicial officers of a court could be useful, and not necessary that a lot of wallet. But for sure, a judicial wallet is essential, because currently with the mnemonic, all debtors are able to back up the wallet in another device, and to use the cryptos with a list of words, and so you can also know them mechanically without some paper documents, and so it's essential the transfer of, but also according to the recommendation of the UIJ, it's essential the transfer of the cryptos. It's very difficult to apply the rule of law to something that disappear very easily, and it's difficult to find. So it's necessary to do something else than the ordinary way of foreclosure. So I think that, but I will listen to your other indication of the recommendation, because it's really a new topic, and it's not easy to find something.
Yeah, we have some answer for this question. I'm not just ask just because I want to have a question, because our next speaker will be Oleg Shaulka, English solicitor, legal director of Kennedy's, one of the biggest world legal company, and he's also Ukrainian advocate. And as I know, he has some answer according to English law to recovery and how hedge virtual assets that was hide or that was fraud from owner. And after Oleg's speech, I will pass word for our cyber and crypto international expert to Tatiana Dmitrenko and Vasil from MLBot. They show to us real detective job, how it's work in real practice cases, and after this we will have some session about question and answer. Oleg, please, I will share your presentation. Thank you for your participation, for your time. 1 minute.
Thank you very much, Alex. First of all, thank you very much for inviting me to speak on this panel. It's a privilege to be among such a distinctive speakers. To put my report into context, and I'm actually very curious to complement what Maximilian just said about the tools that can be of assistance to actually find crypto where the data is not really cooperating, which is usually the case, actually. So I'm pretty sure Maximiliano knows the state of play. Quick introduction. I'm a legal director of Kennedy's, based in London. I started my practice at Clifford Chance back in 2014 with the financial investigations and investigations of the fraud with financial instruments. And that slightly developed now into the fraud and assets recovery. And one of the parts of my practice is actually recovery of crypto assets. Conscious of time, I will be quite brief with the intro. So effectively, from our side, when we're talking about foreclosure, as Maximiliano put it rightly, we divide foreclosure into two parts. Part one is to trace the assets that have been stolen or moved illegally. And part two is to what we can do to recover it. And obviously, all our clients have a question right at the beginning of our instruction. Can we actually get to the asset? So is it worthwhile for us to invest hundreds of thousands of pounds sometimes into the legal action without a guarantee that we actually can recover it? So this is a very serious consideration. And before a substantial analysis, it's just impossible to answer that question. But the most important tool that we offer our clients, and I think that's what Oksana said at the beginning of this presentation, where some less sophisticated jurisdictions can have an ambiguity on this, is that what we can do to stop the fraudster or the criminal to dissipate the assets, to move asset around. So even if we win a judgment against this particular debtor or criminal, can we actually seize the asset and release the asset? Can we foreclose? So the main tool here in England, and I'm sure the panel and the audience know, this is a freezing injunction. This is something that the UK court, English court in particular, are very famous of, and it's a very powerful tool, especially when you act in less sophisticated jurisdictions like Ukraine and Central Asia, like Kazakhstan, Uzbekistan. I'm not saying that the English jurisdiction is incredibly sophisticated in crypto. This is a very fast-moving and dynamic area of practice. But for various reasons and because of the commercial activity of this particular jurisdiction, we do have tools which are a bit more developed than others. But all these tools are based on the fundamental principles of interim measures, which are, again, very powerful in England. And I would like to present one of those tools here. It's a freezing injunction, which can be applied to the debts outside of England. Because in reality, again, the theory is that you have to apply for English court only when you have assets in England. When you're talking about the crypto assets, in 99% of the cases, crypto assets which have been stolen or used as a tool to move the value is not in England. So that's the reality on the ground. And therefore, we have a dilemma how we can freeze the assets somewhere in offshore, for instance, account, or the wallet that we cannot identify. So by the time when we have a civil action for recovery finalized and rendered, how we can be sure that the crypto asset in value will be there for us to seize, to foreclose. And for that matter, English courts developed quite a significant tool for the creditors that I would like to talk about today. And I think that something is very relevant for our colleagues in Ukraine, especially when you're talking about enforcement, because something that not that many practitioners in Ukraine realize that WFO, which is a war freezing injunction, can be obtained in support of Ukrainian proceedings or any other proceedings in foreign jurisdiction. This is very a serious thing, and it's very contextual as well, because most of the time, Ukrainian debtors, especially when they use crypto in Ukraine to move the value of the crypto outside of the jurisdiction. It's very rare when the crypto holders or cash-rich wrongdoers moving crypto between one wallet in Ukraine to another wallet in Ukraine to exit in fiat or into hard currency in Ukraine. It's a very rare case. And that's the only case when our clients are actually considering to go to Ukrainian court and obtain the interim injunction in Ukraine. We call it забезпечення позову or interim injunction. So it's almost impossible effectively for you to stop the wrongdoer from moving the crypto outside of the ecosystem in Ukraine, outside of the hardly controlled, right, the blockchain systems. So you can, by the time you have a judgment, you can be sure that you can actually enforce the judgment in Ukraine and get the assets and release the assets in your favor. So for that matter, we recommend our clients to consider applying for a freezing injunction before English court. This tool obviously requires to satisfy the legal test, but it's very, very powerful, and it's very easy to recognize and enforce in jurisdictions where a potential criminal or a debtor will be willing to exit into hard currency, into fiat. The classic perception or the classic case is that you have a cash-rich individual in a third country seizing the wallet of the victim of the crime or the creditor in this instance, then move the crypto value through various wallets and various blockchains and various transactions into the final point of exit. And that final point of exit can be either resale to the bona fide, to the third party without knowledge of the proceeds of crime, or exit into fiat, which is the hard currency. And exit into fiat, meaning that this is effectively transferring the crypto value into real value. And this is the complication number one, for instance, in Ukraine, because crypto, although we have quite a significant step forward with recognizing crypto as a real property, in Ukraine, there's still a lack of case law where the Ukrainian courts see the crypto assets as assets in real term. And this is the same problem in many jurisdictions, including Italy, as far as I'm concerned, and including here in England, is that crypto is still a class of property which is not properly defined. And if you cannot define the property, you cannot understand or prove your case to operate with this property in real terms, in a normal way. It's like if you compare the tangible property like a house, it's a tangible property you can foreclose against. So it's a house, very hard to move. It's something that you can touch. The crypto, or rather digital asset, is something you cannot touch, and it's just abstract value. It's a promise that someone will pay for this particular crypto code in the exit. So now here in the UK, we have a very significant development which rectifies this particular nuance. The case called AA against person unknown, and where English court recognized the crypto, or rather digital asset, as a real tangible asset, and offer the creditor to apply for a freezing injunction. This is a massive step. So effectively, the English court said, yes, crypto value is a real property, similar to the car, similar to the house, similar to the cash on bank account. And the law commission here in the UK is due to issue the report with recommendations to create a third class of property under the English Civil Procedure Code, which will be called digital assets. And that means that this will be possible for us practitioners, including in Ukraine and other jurisdictions, to operate through the English courts with crypto in a normal way, which actually opens the gate for us to all sorts of interim injunctions, including freezing injunction, because again, freezing injunction is the most powerful tool which you should consider when you're dealing with crypto. Okay, so I think it's point when I need to explain what is the freezing injunction in legal terms. So we all heard about the freezer, or like freezing accounts and so forth. It's not really a freezer in the terms we understand it. Freezing order or freezing injunction prevents a particular debtor to move assets around with the aim of dissipation those assets. So in other words, the order of the freeze prevents a debtor to hide the assets from the creditor by the time the creditor obtains a judgment against the debtor. It does not prevent the debtor to operate his business, for instance, in the usual way. It does not prevent the debtor from taking money for his personal needs and legal representation, for instance, but it does prevent the debtor from moving or dissipating the assets. So Also very important to know is that within the standard wording of the freezing order, there is an obligation, and I think Massimiliano, that's what you was presenting earlier with the development in Italy, that the debtor, or rather respondent to the application to the WFO, to the order, usually requires to disclose within a very short period of time a list of all assets worldwide they own. So that includes pretty much everything they own directly or indirectly. And since the crypto asset is now classified as property, that also means that they need to disclose crypto assets. And that's a very significant step, because if you fail to disclose a single thing which is in your possession directly or indirectly, you can be held as contempt to court. And with the relevance to the Ukrainian case law, we have a recent case back in 2023, last year, which WWRT against Mr. Sergei Tishenko, where the English court summoned Tishenko in relation to the freezing of his assets because he refused to participate in court hearings and refused to actually disclose the assets in the usual way. And the English court ordered his arrest and forced him to appear before the court to testify. Apart from the usual humiliation of appearing before the court, because this is, as you will know, it's a pretty serious stress. There was also quite funny things also can happen. For instance, when the respondent declares a property, a villa, this is not about Tishenko, but just about my recent client. When the client disclosed the villa in Monaco and the pink cabriolet, and his wife didn't know about it, that such assets are actually part of the family estate. So when you launch in the action for the freezer against a particular debtor, this is not only impacts your chances of freezing the crypto assets. It's a very serious tool to launch the pressure on the other side, and then pressure can be used to ask them to cooperate with you, especially on the crypto side, because as Maximiliano also said, the cooperation of the debt is very important in the UK as well. So, and as I said, in another case, for instance, in BTA Bank Abyazov, when Mr. Abyazov refused to declare his assets, he was sentenced for 22 months in prison by the English court. So it's very serious too. And the Ukrainian debtors are now awakened to the opportunity to actually obtain the war freezing injunctions on crypto as well as other assets through the English court in support of the Ukrainian proceedings or any other proceedings in other jurisdictions. So I think the logical step will be to understand what is required for obtaining a war freezing injunction. What is the test that the creditor or, for instance, the executor needs to satisfy? Since it's such a powerful tool, the test is quite serious. But that said, if you find any fraud related to crypto, and since the crypto is such a liquid asset to move around, such an easy thing to move, the WFO test, it's easier to satisfy than with other properties. And the test is the following. I will read from the CPR code now. So to obtain the WFO, the claimant must demonstrate 5 elements. Substantial cause of action, which means that the legal claim allows the party to seek judicial protection. So in any case of fraud, that's satisfied pretty much automatically. a good and arguable case, which means that the claim must be more than speculative and presenting a strong legal argument. And this is something which is very relevant to the agenda of the next speaker, because when you develop in the case for foreclosure or recovery of crypto assets, you have to do quite a significant homework or preparation work. So you have to, most of the time, you have to do your tracing. Most of the time, you have to identify where the crypto is, in which jurisdiction at least, or at least attempt to try to understand where the data exited in fiat or in value. And for that matter, you have to basically demonstrate to the court that this is actually a real case. You have strong arguments, and there is a strong preposition that was the fraud against you, or is the risk of money laundering, and so forth. So the next element is jurisdictional grounds, and that's something that Ukrainian practitioners in particular will be interested to know. So although the WFO is mainly obtainable in support of the Ukrainian proceedings in that particular matter, since I saw the question in the chat, you have to show or demonstrate that there is a strong possibility that the debtor got assets in the UK or has in personam jurisdiction in the UK. For instance, he's a resident in the UK, or got the property, or even to the extent where you have a debtor who is transferring his money through the UK bank account. In my recent case, in Privatbank Kolomoisky, we established the jurisdiction for WFO only for the reason of Mr. Kolomoisky transferring some of the fraudulent assets through the BVI company, which is not even the UK company. And that BVI company related to the UK company. So when you're talking about the complex issues of jurisdiction, obviously it's not easy thing to satisfy. When you're talking about the crypto being used to buy a house in London, for instance, that's completely different matter. It's very popular, by the way, to use the crypto to purchase property in the UK. And the final thing, the fifth element, is the real risk of dissipation. This is, again, real risk. It's very easy to satisfy with crypto, which means that you have to convince the court that it's actually easy for the debtor to move assets. And as we know, crypto is incredibly easy to move within a few clicks away. So in the decision of Yelena Vorontseva and Money for Limited, the freezing order been granted on a substantial quantity of Bitcoin and Ethereum in light of a real risk of dissipation of crypto, without even going into a legal analysis of how easy to move and so forth, because it's such an implied thing. So I think to conclude, I need to focus your attention on preparation for application of the freezing orders, if you think that this is a course for you. And I highly recommend to include that into your portfolio, especially if you are executor, for instance, in Ukraine. The WFO, the freezing order, can be obtained either before, during, or after the proceedings. So it doesn't matter when you apply for it. The key point is, and the key point to understand, is that it can be obtained in support of the foreign proceedings. It can be used as a tool of pressure in a way that obviously you are not blackmailing the other side that you're going to obtain, or you obtain only for that. You have to have a real intent to actually prevent dissipation. But as a collateral consequence of the WFO is that the other side will be under significant pressure. And maybe just for the risk of being frozen by the WFO, the other side will cooperate with you. And the final point that you need to remember is that the WFO is reasonably easy to obtain with the crypto, subject to the preparation work. And that preparation works requires asset tracing, the exercise of asset tracing. So you can trace crypto assets through the legal means. So in the UK, for instance, we have a particular orders which require third parties to disclose the assets, or in particular crypto assets, like bank's trust order and normal farmical order. So you can apply for the application to the court. So the court can order a third party, for instance, the exchange, to disclose the blockchain way of a particular coin. This is obviously not without nuances. The blockchain can ignore the order, for instance, but it's a real possibility that you can actually do that. And the final point, this can complement your own offering in your own jurisdictions. So it does not dismiss your actions, since in Ukraine, for instance, when you enforcing your judgment in Ukraine, it will be complement to what you're already doing. And that will something that obviously we need to talk about another time. Thank you very much.
Alex, thank you very much. I have not any question because I prepared some question about procedure and requirements to using English law and English jurisdiction, but your presentation was very full and you clarify all question. So just from my opinion and general recommendation for our clients, for our debtors, don't wait in first, and second, to use very high qualified legal expertise for crypto enforcement and crypto recovery, because for my opinion and from my experience, and also Massimiliano and Oleg can be agree with me, when clients waiting for something, waiting for some action from law enforcement and waiting for some policemen in one country find mine assets, it's unreal. Unfortunately, it's not way for real recovery. It just waiting for, I don't know, which unrealistic justice, because main point of all crypto assets, it's very fast transfer assets. For minutes, it can be changed dozen or 1,000 different wallets. That's why you need to use a special law enforcement procedure, special advocate, very qualified advocates from different jurisdictions, and of course, crypto detectives. And I want to pass word to Tatiana Dmitrenko, Dr. Tatiana Dmitrenko, head of Ukrainian Modern Digital Science NGO. And after she now main time working abroad and working with different governments, not just Ukrainian governments. And after we will speak with real detective team from MLBot and Vasil in person. So Tatiana, for your welcome speech, thank you for your participation.
Thank you, Alex. Thank you. Greetings to colleagues and participants of our meeting. I have a short speech without presentation. I would like to share with you some innovation on asset recovery in Central Asia countries and the approach to regional cooperation. At the end of May 2024, under the auspices of the UN Global Project in Central Asia, and with the participation of the UNODC and the World Bank Stolen Asset Recovery Initiative, STARS, and the OSCE, representatives of the General Prosecutor's offices and anti-corruption agencies of Central Asia countries launch a project to unite efforts is recovering stolen assets, including crypto assets. Among the 5 Central Asia countries, the Republic of Kazakhstan is the leading nation in the implementation of FATF Recommendation 15, the legalization of mining, and the regulation activity of the crypto markets. They have willingly agreed to share their experience with other countries in this region. What was particularly interesting was the consideration of the recovery of crypto assets within the framework of existing legislation on the return of stolen assets, but with methodology tailored specifically for crypto assets. It was noting that in Ukraine, after adopting basic AML safety legislation, with the implementation of FATF Recommendation 15 on virtual assets, the anti-corruption system authorities update the legislation and relevant article of the criminal code, adding virtual assets to the list of recoverable assets. They did not wait for the adopting of the basic law about virtual assets. This highlights that where there is willingness to work and political will, challenges and threats posed by new innovative technologies are addressed and criminality is prevented. Given the global nature of the crypto markets and digital technologies, when it comes to the recovery of crypto assets, it's essential to unite the efforts of different states of region around the world. I now hand over the floor to the asset recovery practitioners. Every strategy must be backed by effective tactics, otherwise this strategy is meaningless. I want to introduce you to Vasil Vidmanov from the AML group of companies who has been working with clients who have lost their crypto assets for many years. Vasil, please.
Yes. Thank you, Tatiana. Hi, everyone. Alex, thank you very much for the invitation.
Yes.
It is great to be here. So my name is Vasily Vidmanov. I'm CEO of AML Bot. And in AML Bot, we have crypto compliance company that helps businesses with compliance. And we also have investigation department where we try to fight the crypto crime and help the victims of crypto crime and crypto scam. So if we can go to the next slide, please, Alex. Yeah, so in this picture, you can see that we have quite a few cases daily even. And you can see some approximate numbers of the amount that we were able to freeze and how much we were able to recover. And I have added this slide not to brag how cool we are, but to show that to freeze the assets doesn't mean that they will be recovered, because the procedures are usually very complex and there are a lot of pieces that needs to be put together. So we can go to the next slide. Yeah, this is just briefly here. You can see that the type of the crypto incidents that we deal with. So the most common ones are the crypto scams and direct theft. So the crypto scams is basically when you are scammed and you send the crypto voluntarily to someone, and then it turns out to be a scam. And the theft is when you are hacked. So you have a malware on your computer that hacks your digital wallet, or if someone steals your device, for example, or gets an access to your phone and then transfers the cryptocurrencies from there. The least common, also the freezing. So when you're a legitimate user and then your assets get frozen on an exchange for whatever reason. So this also happens, but we have less of those cases. So I know that we discussed the investigations, and the previous speakers talked about the legal aspect of the things. So this is just a brief perspective of crypto forensics. So at the starting point, the victim reaches out, he or she provides the evidence and the crypto wallets that were affected. Then the blockchain analyst does the investigation and traces through the wallets that are controlled by the hacker. And of course, the goal of any investigation is to quickly identify where the stolen assets went, because once the stolen assets hit a centralized entity like cryptocurrency exchange, this is where they can actually be frozen and then potentially return to the client. So if we can go to the next. Of course, we cannot do this by ourselves. We are not law enforcement, so we cannot enforce anything. What we can do from our side is we can trace the funds, we can freeze the funds on some exchanges for some short period of time. And we can, of course, communicate with the exchanges, monitor the wallets, and so on. But then when the victim comes to us, the first thing that we advise them, even if they don't become our client, is to file a police report, because the police cooperation will be necessary. So once they file a police report, usually in most of the countries, including Ukraine, we have a cyber department. And then basically the detectives, they need to recreate the trace that we are doing usually, or they can trace even themselves. Again, some of the departments are already equipped with the necessary tools to do the tracing themselves, but they need this evidence in order, again, at the final stage when the assets hit a centralized entity, they need to be certain that those are the same assets that was stolen, that they didn't get commingled, or there was no change of the custody and so on. And again, at the final stage, the police or the other law enforcement agency can send a subpoena or a warrant to an exchange. And after that, the case can get to the court. So if we can go further. This is just the summary. So about what happens kind of at the final point. Once the stolen funds hit the exchange, besides asking to freeze the funds, the police or other law enforcement agencies can also request know your customer information, because this can aid the overall investigation to actually uncover who was the fraudster. And also sometimes it happens that, especially if the hack happened some time ago, so sometimes we get the cases when like 1 year already passed, or 1-2 months. And then if the funds go to the exchange like 1 month or 2 months or 1 year before we got the case, in most of the cases, the funds are not present on the exchange already. So the scammers or the hackers have already withdrawn the funds further. And again, if this is the case, then we or police, we can obtain the information where the funds went next, so we can continue the tracing further. Go to the next slide, please. Yeah, so I briefly outlined the procedure, how it works, and then, of course, there are numerous of challenges. Here, I didn't outline like specifically our challenges, like when the funds go to a mixer, but I wanted to outline the challenges mostly in relationship with the law enforcement, and so basically was a law enforcement. So we deal with numerous jurisdictions, and we had cases in numerous jurisdictions, and some of them still registering a case that relates to cryptocurrency is a big challenge. And it mostly depend on the jurisdiction and also on the particular law enforcement officer and the agency and their willingness to take the case. So how well they are educated about crypto in general, how much they're willing to spend time and to understand the crypto transactions and so on. And then the second part is, besides registering the case, there needs to be a swift action. And this is what we also try to explain to the law enforcement, that in the traditional finances are slower than crypto. Crypto is much faster. And the exchanges, they know that, and sometimes they give a very brief window when the assets are actually temporarily frozen on our request, because again, we are not law enforcement, we cannot enforce the freezing for long. So they give a very short window, and if in that window the law enforcement will not contact the exchange, then unfortunately the freeze will get lifted and the funds may leave the exchange. And of course, in that case, it will be hard to help the client. Then we also sometimes face another issue, that the local police and the cyber department units are usually more cooperative than the special agencies. So this is especially a problem in the United States, for example, that the special agencies like FBI, they have the necessary tools for sure how to do the tracing, but sometimes they don't provide any update, nor to us, nor to the client even, and nor to the client lawyers. So then the client doesn't know what's happening, if the case is still active or not. And then again, the only option for the client is to go to court. And as Oleg was describing about the freezing injunctions and so on. But then again, this complicates the procedure for the client, because he already has come to us, right? He had to pay for our services. Then he has already had to deal with police, especially, and now he also has to engage lawyers. So that's the other point, that there is a cost attached to it. And the last point that I wanted to make is the jurisdictional issues. Through the years, we noticed that the exchanges become more cooperative because they fear the consequences of non-cooperation. But still, if it's an exchange in offshore jurisdiction, like in BVI or Seychelles, once they're contacted by police outside of this jurisdiction, they can easily say that, hey, sorry, it's not our jurisdiction. Please obtain a court order from our jurisdiction, or get the local police from our jurisdiction to contact us. Of course, you can imagine having a relationship with the police in Seychelles on BVI, it's very complicated. So that's another issue. And now I just wanted to briefly talk about some specific cases. And where we cooperated with law enforcement. In this specific case, it's a case from the United States. So there was a typical malware case. So an individual was doing a lot of airdrops. So he had around 200K in his wallet. He installed some software. All of the funds were gone. So once this happened, on the next day, he came to us. On the same day, we were able to freeze some of the funds. So here on the screen, you can see the actual flow of the funds, and it's a bit complicated, but at some point, we were able to freeze the funds on a bridge, on the DeFi bridge, which is, again, is not very typical. And some of the funds were frozen on Binance. And then the rest of the funds were proceed through an OTC. And this is, in this case, it's very hard to understand where this OTC is located. So those funds probably will not be recovered. But around 60K of the funds were recovered. And in that case, the police also did very well. They accepted the case on the same day. And on the next day, they even sent the request. And in that case, the client were able to receive the funds. So that's the summary of the first case. We can go to the next one. The second notable case actually happened in India. So there was the typical scam case when you are as an entrepreneur and founder, you're looking for investors, and you get contacted by fraudulent investors who ask you on a Zoom call to create a digital wallet for more security, and then they see your seed phrase, so they see your private keys, and then they ask also to transfer some of the funds as a deposit, like that you are serious with them. So this is how they tricked him in transferring 100K to this wallet. It was 45 Ethereum at that time, and of course, all of these funds they took from him. So you can go to the next slide. So yeah, so this case was a bit less complicated in terms of the tracing. Again, since the victim was from the tech capital in India, in Bangalore, they also have a pretty advanced cyber unit. And actually, the victim was able to go to the cyber unit to register the case. We were then able to freeze some of the funds, presented our findings to the cyber unit, and then gave them our tools for free in order for them to recreate the trace and to make sure that then the requests that they're sending to the exchanges are actually the ones that needs to be sent. Yeah, so and then I think by now almost 70 or 80% of the funds are recovered. And unfortunately, there is some services that are non-cooperative. So again, it's one of the challenges that we face is that some of the exchanges just don't reply, even to the police. Yeah, and here you can see our head of investigations, Anmol, with Indian cyber police and also with the Thai cyber police. So we have some active cases in Thailand right now, which is a huge, big butchering hub for the scammers, unfortunately. Yeah, so that's it. So I have my LinkedIn profile here. If you ever have any questions or want to chat about any of the topics, I'm always open to. Thank you.
Thank you, Vasil. Thank you very much for your presentation and your practical experience and shown to us better approach from practical cases. So for our colleagues, I just want to remind we are in briefly end our webinar about cryptocurrency, crypto assets recovery and enforcement. And just small information about next week, 12th of September, we will hold additional panel discussion with decision makers and international experts about blockchain, not about just cryptocurrency, about blockchain regulation and about challenges for legislators and how law developed in this field. So who has interest for digital economy, but not for crypto, just for cryptocurrencies and enforcement, about general regulation, about new waves and new information from different government experts and from decision makers, just looking for this information to Ukrainian National Bar Association website, to my page, to Tatiana page, and also we will share this information to Ukrainian Enforcement Officer Association webpage. So main idea of our events today to show about of course, all legal market now have some concern questions about how it's real or not real to enforce cryptocurrency. We are shown to us everything possible, but you should work in common law. If we talk about continental law, Ukrainian, Italian, European law, or we can use a special instruments that provide to us English law, we can find and return and recovery your virtual assets, but you should use not Google, not TikTok advisor, just professional advocates, just professional law enforcement officers, bailiffs, and professional detectives. So thank you very much. Unfortunately, we have no any time because Ukrainian National Bar Association have next international webinar on this Zoom. So be in touch. If you have some question, we can ask to organizer and contact with our teams. Thank you. Have a nice day. See you. Bye.
Thank you. Bye.
See you. Bye.
See you. Bye.